Hello, my name is Donna Rogers, and I will be discussing the issue of whether or not an adoptive mother is entitled to maternity leave. Next slide, please. The case that I will be discussing today involves Carol Fern, a city employee of Bainbridge Borough who has been employed for more than 18 years. Mrs. Fern is a member of the Union of American Federation of State, County, and Municipal Employees, and that union represents the nearly 50 employees of Bainbridge Borough. Mrs. Fern and her husband were pursuing adoption when on April 22nd, they were notified that a child would be available for adoption within 3 days. However, Mrs. Fern knew that this was a difficult time for the city as it was a busy tax month and elected on her own to defer the adoption until May 2nd. On April 27th, Mrs. Fern applied for and was granted paid vacation of 2 weeks from May 2nd until May 17th. Next slide, please. The day before her paid leave was to expire, Mrs. Fern then requested 6 months of unpaid maternity leave per the contractual bargaining agreement. The Bainbridge Council denied her maternity leave request, but instead granted her 2 90-day successive reasonable purpose leaves. Ms. Fern then contacted Local 10 and filed a grievance with the union against the borough per the collective bargaining agreement that her rights under the contract had been unfairly denied. Next slide, please. For the purposes of this discussion, I will be assuming the role of the attorney for Local 10. As attorney and representative, it is our contention that the borough did knowingly violate 2 counts of the collective bargaining agreement, namely Article 10, Section 4.A, Paragraph 5 regarding maternity leave, and Paragraph 1 regarding reasonable purpose leave. It is also our contention that the Bainbridge Borough also violated federal law, namely Family and Medical Leave Act of 1993. We seek relief and remedy of the grievance through the reversal of the denial and approval of the maternity leave per the specifications of the collective bargaining agreement. Next slide, please. The first violation is regards to maternity leave. There is no stipulation against in the collective bargaining agreement regarding the timing or time frame of the leave. While it was short notice, the union does acknowledge that it was not outside the collective agreement. Secondly, it is our contention that the council denied her leave simply because she is the adoptive mother and not the biological mother. However, the intent of maternity leave is twofold: one for the health, welfare, and well-being of the mother, and also for the bonding and caring of the infant. It is because of this, then, that maternity leaves are therefore granted, and it is interesting to note that the federal mandate specifies that if a company has a maternity leave policy, they must also grant paternity leave. Given all of these findings, it is our contention that the adoptive mothers are therefore covered under maternity leave. Therefore, maternity must be granted to Mrs. Fern, as the wording of the contract stipulates that it shall be granted at the request of the employee. Therefore, the council cannot refuse to grant this leave to a requesting employee, whether it is for maternity leave, paternity leave, adoptive, or biological parents. Next slide, please. The second part of the grievance is in regards to the reasonable purpose leave. The first finding lies with the fact that reasonable purpose leaves are to be agreed upon between the union and the council. And the union notes that there was never any kind of notice regarding a discussion of this kind of leave or the awarding of this leave to Mrs. Fern. Therefore, this act alone is in violation of the collective agreement, and the union charges the council with bad faith in the agreement, which resulted in unfair labor practices against Mrs. Fern and the union. Next slide, please. Local 10 also charges the council with violation of federal law in regards to the Family and Medical Leave Act of 1993, which clearly allows for the rights of adoptive parents to take up to 12 weeks of unpaid leave. FMLA applies to the borough council because the city employs more than 50 employees, and Mrs. Fern herself has been an employee of more than 1 year, which is a requirement. In addition, Mrs. Fern is also in compliance herself because she is requesting this unpaid leave during the 1-year time frame that is specified for adoptive parents. Next slide, please. In keeping with the terms of the collective bargaining agreement, Mrs. Fern approached Local 10 to file the grievance which we have filed against the City of Bainbridge, and we are still awaiting response. As per the union notification process, Local 10 has also notified the National Union so that they are aware that there has been a local grievance filed. Therefore, should the grievance process need to be escalated, the union is already aware of and has been kept apprised of the events leading up to that event. Should it also become necessary in the process to file a grievance with the National Labor Relations Board, it will be the National Union representation that will do so on behalf of Mrs. Fern and Local 10. In addition, union representation may find it necessary to file a complaint with the Wage and Hour Division of the Department of Labor. This notification process can be done concurrently at any time during the grievance process. Next slide, please. Should the grievance process become stymied within the union process, or the outcome is not favorable, the union will also advise Mrs. Fern that she can sue the employer herself, but will need to employ her own attorney to do so. While historically the courts have deferred to union management, arbitration, and grievance processes, it's come to light that many employees have been denied their rights simply because they've not been fairly represented and need the protection of the courts to assert these rights. Employees who feel that their employers have breached the collective bargaining agreement may file suit in either federal or state court under Section 301A of the Labor Management Relations Act. Since 1955, the courts have continually revised the parameters for bringing suit in court, with the current consensus allowing for either individuals or the union to bring a federal suit against an employer once the grievance process has been exhausted. However, when an individual's civil rights have been violated or when a wage and hour claim has been alleged, the employee falls under the exceptions that have been predetermined by the court, and the employee can bypass the entire grievance process. However, it is important to note that an employee that chooses to bypass the grievance process must have clear factual evidence to bring to court, and it is therefore advisable that an employee seek redress and remedy through the grievance process first. Next slide, please. In summary, then, it is Local 10's contention that Bainbridge did knowingly violate 2 points of the collective bargaining agreement as well as federal law. It is our position that they need to immediately rescind their earlier denial and instead approve of the maternity leave and grant it retroactively to May 18th with all protections for wage, job, and employment security intact. Furthermore, it is the intention of the union to continue to escalate the grievance up to and through the courts if necessary. Thank you for allowing me to speak to you today regarding the rights of adoptive parents to exercise their rights regarding maternity leave.